So guys, what's up, welcome back to the channel. And in this revision video we are going to cover the revision of the chapter charges, and it is a very small, very easy chapter. Not a very difficult chapter, but yes, it is a very important chapter because before May 2025, if I'll say, student used to leave this chapter because I say do not ask much questions from this chapter, but now from this chapter they are asking the questions again and again. So this is also very important, and please give the same importance to this chapter also. The importance you used to give to FEMA, LLP, share capital and debenture, management administration. This chapter is also equally relevant and important. So let's start very quickly and we will complete this chapter very quickly today. So this is a very small chapter and you are going to cover the sections from 77 to 87, and they are very small sections. So we are going to revise the sections very thoroughly, and at last we will discuss the questions also. And if you are new at the channel, then please do subscribe the channel for more such content and for more such updates and every strategy, motivation, everything. And if you want these board notes, then you should join the Telegram channel. The link of the Telegram channel is given in the description box. Right, sir. Now we will start with the chapter, that is chapter number 6, that is charges. Sir, what is the meaning of the word charge? The meaning of the word charge is whenever a company takes a loan, whenever company borrows something, so company will create a charge in the favor of lender. The company will create a charge in the favor of lender as a security that yes, we will be repaying our loan, we will be repaying our borrowings. For that, the company keeps a security with the lender. That security creation is called as a charge creation. And charge means any interest or any lien created on the property of the company, asset of the company, or any undertaking of the company. Sir, what is the lien? Lien means you are giving a legal right to possess something that person can possess because he is having a lien on your assets or lien on your property. So whenever you create a interest or a right in favor of some kind of lender, then you will say that you have created a security, you have created a charge. As per the normal general laws, if you will say that there are three words, one is mortgage, one is pledge, one is hypothecation. Sir, what is the difference between mortgage, pledge and hypothecation? When we talk about the word mortgage word is generally used when you keep the security of an immobile property. Then we use the word mortgage. When we use the word pledge or hypothecation, they are used generally for the movable property. Then sir, what is the difference between pledge and hypothecation? See, when you do the pledge, it means you are keeping a security of a movable property. So when you create a pledge, then the possession of that movable property or movable asset is being transferred to the lender. Or you can say that you are creating the pledge, you are pledger. The person in whose favor you are creating the pledge, that person is called as a pledgee. So the asset will be transferred to the pledgee. Possession will be given to the pledgee. That is called pledge. But in case of hypothecation, the charge is created, but the possession will not be given to the lender. For example, if you purchase a car on the finance. So when you purchase a car on the finance, the car is being financed by the finance company. They have given you the loan, but you are riding your car. You are not, like, you have created a charge in the favor of that lender. If you will not pay the installments, they will take that car with them. They'll not, like, they will give a punishment to you and they will take your car away. But if you understand, if you are having that loan, if you are creating that security, but still car is with you, you are not able to give the possession to, you are not supposed to give that possession of car to that person or that lender. That is called hypothecation. So the basic difference in pledge and hypothecation is that in case of pledge, the possession of the asset is transferred to the lender, but in case of hypothecation, the possession of that asset on which charge is created is not transferred to the lender. So in general life, we talk about these, that mortgage is different, pledge, hypothecation is different, but in Companies Act, we do not create any differentiation between mortgage, pledge, hypothecation. This is charge means this, and it includes the mortgage. That means if you will create a mortgage, that is also covered in the definition of charge. If you will do the pledge, that is also covered in the definition of charge. If you will do the hypothecation, that is also covered in the definition of the charge. Further, you can create the charge on the movable property. You can create the charge on the immobile property. You can create the charge on the tangible assets. You can create the charge on the intangible assets. Even you can create a charge on your debtors also, on your book debts also. That amount will be recoverable, amount will be recovered from the debtors and will be paid to you if in case of default. So you can create a charge on the debtor also. You can create a charge on your uncalled capital also. For example, you have issued a share of rupees 10. Right now, up to present date, you have you only called rupees, let's say the share is of 10 rupees and you have only called rupees 6 only. So that 4 rupees is your uncalled capital. That can also be kept as a security. On this uncalled capital, you can create a charge. Sir, for example, if the company takes a loan, if the company borrows something and company will not be able to repay that loan, then that uncalled capital will be called and the amount will be paid to the lender in case of default. Oh, so you can create a charge on the uncalled capital also. Right, sir. So this was a basic discussion, what is charge and everything. Now one more basic topic is there. Usually institute do not ask this question, but I think they asked this question in May 25 examination about this floating charge. So they ask very, like, after 2-3 attempts or 3-4 attempts, but yes, they ask. So you have to learn this topic also, that what is the fixed charge, what is the floating charge. Fixed charge is the charge which is created on the existing assets. The present assets what you are having right now, only on that asset the charge is created, and this charge is a fixed charge. It means the assets on which you have created a charge, now it will be shackled. Now you will not be able to sell them, you will not be able to like you will not be able to sell them, you will not be able to transfer it to some other person. That asset is now under charge. That charge is called as a fixed charge. For example, the charge on the building. For example, company is owning a building, company is having a building that is owned by the company, and company created a charge on that building in favor of the lender. Now the company cannot transfer that building. Now the company cannot sell that building. The company is not permitted to sell the asset on which the fixed charge is created. And I said that fixed charge clutches the property. It shackles the property. You are not allowed to sell it now. But if I'll talk about floating charge, so what is, sir, floating charge? Floating charge is a charge which is created on the existing assets as well as future assets. Students mostly do a mistake in this point, that they think fixed charge is a charge which is created on the present assets, and floating charge is a charge which is created on the future assets. No, floating charge is a charge which is created on the present as well as future assets. It will be created on the present assets and future assets also. Sir, why? How? See, floating charge is a type of charge which is created on such assets which are fluctuating in nature, which are not fixed in nature. For example, you have created charge on your stock. Now, if you have created the charge on your stock, and if that asset will be shackled, that asset will be clutched, then how you will be able to do the business? You have to sell that stock or not? Yes, sir, we have to sell that stock. Then here it is allowed. You can sell it, you can do the trading, you can do that. Nothing is restricted here. But if you will sell the stock, for example, you have taken the loan of let's say 5 lakh rupees, and you have created a charge on the stock of 5 lakh. Now you are allowed to sell that stock. Now you have sold the stock of 2 lakh rupees, but again you have to purchase some stock and you have to maintain that limit again. So it means right now you are having 5 lakh rupees stock. On that the charge has been created, but out of that 2 lakh rupees stock you have already sold. Then the future stock will be coming, it will be by default under charge. So I am saying that floating charge is a kind of charge which is created on the present asset as well as on the future assets that are indeterminable. Present assets what you are having right now in your hand, that are determinable. Now you are able to determine how much assets you are having in your hand right now. But the future and indeterminable assets are assets which will be coming in future, but the charge will be created on them also. For example, you are creating the charge on the stock or on the debtor, and the company is permitted to sell the asset on which floating charge is created. Even it can be used for the trading purpose, or you can use it for the making your final product. For example, you are having stock of raw material that you can also use to make your final product. But yes, you have to maintain that limit every time whenever the stock will be checked. And the floating charge do not clutch the property. Definitely you can sell that. Then there is a topic called crystallization of floating charge. So there are some cases when the floating charge will become the fixed charge. When the floating charge will become the fixed charge, it means it becomes a fixed charge. The floating charge will be converted into fixed charge. That is, crystallization takes place. What is crystallization? That water is turning into ice cube. Floating charge is converted into a fixed charge. That is called crystallization. For example, these are the cases like when the company goes into liquidation. When the company is not going into liquidation, but the business of the company is seized, then also the crystallization takes place. The aggregate value of the property on which the floating charge was created is now falling down and it is less than the amount borrowed. Then floating charge becomes fixed charge on the asset available as on that date. And if the company violate any terms and condition and the creditor enforces the security, then also the floating charge becomes the fixed charge. Now we will start with the sections part. We have to understand the section part. Section number 77 says that whenever the company creates a charge, it is the duty of the company that that charge is to be registered with the ROC. You have to get that charge registered with the ROC. Sir, whether charge is created outside India, still we have to register? Yes. Charge is created on tangible asset, intangible asset. Charge is created on the property which is situated in India, outside India. Whether charge is created in India or outside India. See, there is a difference between charge created in India and property situated in India. When I am saying charge created in India means the lender is of India. You have created a charge in India. Suppose you have taken the loan from outside the country. You have taken the loan from USA, lender is in the USA. You have created that charge even outside India. Still also that charge needs to be registered with the ROC. You just keep this thing in your mind. You have to remember one point, that if the asset is tangible, whether the asset is tangible, intangible, whether the asset is in India, outside India, whether the asset is in India, outside India, whether the charge is created in India, outside India, whatsoever the charge you will create, you have to get that charge registered with the ROC within 30 days of the creation of charge. If you are creating the charge for the debentures, then you have to file the form CHG 9. In all other cases, you have to file the form CHG 1. And please note one more point here, that it must be signed. It must be signed by borrower and charge holder. It must be signed by borrower as well as charge holder. Charge holder means the person or the lender in whose favor you have created the charge. And you have to attach the copy of instrument also. Sir, what is the copy of instrument? Instrument, that is like loan agreement or any instrument by which that charge is created. That copy you have to attach also. Okay, sir. And you have to give the fees also to the ROC. Now, I have already told you this point, that asset can be any asset, tangible, intangible, financial asset, whether asset is in India, outside India, charge is created in India, outside India. You have to get that charge registered with the ROC. One more point you have to learn, that the copy of the instrument is the evidence of creation of charge or modification of charge. If you have created the charge or if you have modified the charge. What is modification of charge? In few minutes, we will discuss that modification of charge in section number 79. But right now you understand what is modification of charge, like something you have modified, like rate of interest you have modified, etc. That is called modification of charge. So that copy of instrument will be the evidence that you have created a charge. If you have modified the charge, then again there must be some instrument by that the charge was modified. Then that copy of instrument is to be considered as the evidence of the modification of charge. So that copy of instrument is to be verified. Now, who will verify that copy of instrument? Who will authenticate that copy of instrument? You have to check that asset is located outside India or asset is located in India on which the charge is created. If the asset is in India on which the charge is created, then the director of the company, company secretary of the company, or authorized officer of the charge holder can verify. These three persons can verify. But if asset is located outside India, then common seal that can be authenticated under common seal of the company, or director or CS of the company, or authorized officer of the charge holder can also verify, or even any other person, some other person can verify if he is also interested in the same property. Right now, this is very important time limit. Sir, if we are not able to get that charge registered within a period of 30 days, you have said that your charge must be registered with the ROC within a period of 30 days. But suppose, sir, we were not able to register it within a period of 30 days. Director was busy in his honeymoon. In his honeymoon, he was not aware of anything, and all others were like, and they are not able to get that charge registered. Then what will happen? If you will not able to register this charge within a period of 30 days, then what you have to do is you can file the application to the ROC for an extension. ROC may grant you the extension. If ROC grant you the extension, then in the next 30 days you can get that charge registered, but now you have to pay the additional fees. And sir, suppose if in this period also we are not able to get that charge registered, then then what we will do? Then then you can make an application to the ROC, and that will be a second extension. And that second extension may be granted for up to 60 days. Here the extension can be given for up to 30 days. Here the extension can be given for up to 60 days. And in this case, you have to pay the ad valorem fees. Sir, what is ad valorem fees? Ad valorem is a Latin word whose English is according to the value of loan. And according to that value of loan, a fees will be applicable to you. You have to pay that ad valorem fees and you can get that charge registered. But sir, suppose this 120 days are over. Original 30 days were given to you. You have to get that charge registered along with the fees. But if you are not filing any form for registration, then you can get first extension for 30 days, up to 30 days. Then you can get the second extension up to 60 days. But sir, suppose 120 days is over and still not the charge is registered, then what will happen? Then there will be some consequences that will be under 77 subsection 3. We will discuss in the last. And under section 86, there will be the consequences that will also be applicable. Right, sir. Whenever you will file the application for extension, it must be filed to the ROC and you have to attach a declaration signed by the CS or director of the company that we are filing this application for the registration of charge late. We are filing the application to you for the extension. This belated filing is not going to affect any intervening creditors. It means that when this charge was created, and now we are filing the form for registration of charge, we are asking you for an extension. In the meantime, if any creditor is also involved in the company, now we have taken some credits, more credits from some more creditors, their rights and their interests are not getting affected because of this belated filing. So you have to file a declaration also. And then ROC will register your charge and ROC will issue you a certificate of registration. Now understand very, very, very slowly that there are two cases. First is whenever you create a charge, fresh charge is created, and that you have to file CHG1 to the ROC. ROC will register the charge. In that case, when ROC will give you the certificate of registration of your charge, ROC will give the certificate in the form number CHG2. ROC will give you the form in CHG. ROC will give you the certificate of registration in CHG form number CHG2. But when your charge was modified, in that case also you have to file CHG1 to the ROC. Oh, listen to me very carefully what I am saying. You have to file CHG1 in both the cases. Instead, in 3 cases, you have to file CHG1. Sir, what is third case? That I am going to tell you in section 79. There are 3 cases when you have to file CHG1. When the fresh charge is created, you have to file CHG1. Then you will get in return the registration of charge, certificate of registration of charge in the form number CHG2. When you will modify the charge, then also you have to file the form CHG1. And in that case, the ROC will issue you the certificate of registration of your modification of charge. That registration certificate will be granted in the CHG3 form. So ROC will give you the certificate either CHG2 or CHG3, that depending upon the case for what purpose you have filed the CHG1. Oh, and you have to learn this point, right? These forms are very important. And the certificate issued by the ROC will become the conclusive evidence that provision of the Companies Act 2013 and the applicable rules made thereunder, you have complied all that provisions of the Act also and of the rules also. Now there is one more section which is very interesting, section number 78, and this states that section 77 imposes a duty on the borrower that you have taken the loan, you have created a charge, you should file CHG1 to the ROC and get that charge registered. But you just understand. Later on, I'll tell you, if this charge do not get registered, then who will be at the ultimate loss? That is lender. That is, lender will be at the ultimate loss. He will lose his priority. That secured creditor will be reduced to the level of unsecured creditor because his charge was not registered by the ROC, with the ROC. Now, section 78 says that charge holder, you just come to us and listen very carefully. Law is saying to the charge holder that charge holder, even if the company has not filed the CHG1 to the ROC within the original period of 30 days, now it is your responsibility that you may file that form to the ROC. You can file now, because it will be your benefit if that charge gets registered. If the charge remains unregistered, that will be your loss only. But that doesn't mean that company is not having any duty to get that charge registered. Earlier, the primary duty was of the company. If the company fails to file within that period, that original 30 days, then the charge holder can also file CHG1 to the ROC. But directly charge holder cannot file the CHG1 to the ROC. Charge holder will file first CHG10 to the ROC and ask for the permission. That company has not filed CHG1, whether I should file the CHG1. Now ROC will issue show cause notice to the company. that so and so person is coming to us and saying that you have created a charge in favor of him, whether we should register the charge or not. Now there can be three possible cases. First, company says, oh, I forgot. Company says, oh, I forgot. Now I recalled, oh shit, I have to file CHG1. And now the company files CHG1. Then the game is over. But case 2 is the possible case. Case number 2 is company shows the sufficient reason. Company shows the sufficient reason to the ROC and saying, sir, see this. That is why we are not filing CHG1. So the ROC will not grant the permission to that person. For example, company says that person has sanctioned the loan, but still we have not received the amount in our bank account. Amount is not yet credited. How we can register that charge? That is why we have not filed CHG1. ROC says, oh, so ROC will not grant the permission. But if these both the cases are not the case, then the third case is company is not responding. And if the company is not responding, ROC says, Now sit at your home. ROC within 14 days of the SCN grant the permission to the charge holder to file the CHG1, and then charge holder will file the CHG1 to the ROC. And when the charge holder files the CHG1 to the ROC and the charge will be registered, whatever the expenses the charge holder has spent, that expenses will be recovered by the company. That all the fees and expenses will be recovered by the company. He will recover from the company. Now section 79 is very simple section. It says that whenever you modify the charge, like you have modified the terms and condition of the agreement, loan agreement, you have increased the interest rate, you have decreased the interest rate, or your extent of charge is increased or extent is decreased, whatever the case may be, you have to file the CHG1 also. Yani in modification also you have to file the CHG1. There is one more case very important, and institute has asked question on this point also, that if a company is acquiring any property subject to charge, which means that is the property, and on that property already charge is created. Now this company has purchased that asset from that company. So now new borrower is this company. This company again file a CHG1 to the ROC. Sir, please explain with the example. For example, there is a company that is Reliance. Reliance has taken a loan from the SBI and created a charge in favor of some asset and created a charge in favor of SBI on some asset. Now there is a company called KK Limited. KK Limited purchased the same asset on which the charge was already created. Yani this is the property which is under charge. This is the property which is already under charge, and KK Limited has purchased this property, this asset. Then KK Limited is required to file to the ROC. Required to file the ROC CHG1 that we have acquired that property which is already subject to charge. So section 77 says that when you create a charge, you have to file CHG1. But 79 says that if you acquire a property which is subject to charge, and if you do the modification, in both the cases, you have to file the CHG1. And if you assign the rights of charge holder to some third party, that is also considered as a modification. In that case also CHG1 is to be filed. Now there is one another section number 80, and that is also very important section because institute has asked question on this section also. That is called deemed notice. Deemed notice, or you can say constructive notice, a notice to the public at large. For example, company has created a charge on the asset. So from the date of such registration of that charge, it is like a deemed notice to the public that we have created a charge on this asset. Now, whosoever is transacting with the company and wants to purchase that asset, that will be his responsibility that you should check that this asset is already under charge. And institute has asked a question. Let me tell you that question also. For example, there is a question, Mr. Antriksh is a person, and that Antriksh purchased the property from a company, let's say KK Limited, and KK Limited already created the charge on that asset. But Antriksh has purchased that asset from the company, and Antriksh was not aware of this thing that the charge has been created or not. Later on, when the Antriksh went for the registration in his name of that asset, then he get to know that the asset was already under charge. Now he came to company, and company denies the liability. Company says that the asset will not be transferred in your name because that is already under charge. Whether Antriksh is saying no, company has to inform whether his contention is valid or not. his contention is invalid. Company need not to inform. Company says that this charge was registered. When this charge was registered, from the date of that registration, it is a deemed notice to the public at large that we have created a charge on this asset. If you are transacting with us, it is your responsibility that you should check from the website of ROC. From the website of ROC, from the website of MCA, go and check it. That is not our responsibility. Then section number 82 says that if the company makes the payment for the loan, then the charge you have registered, now you have to file the form for satisfaction of that charge, that yes, we have made the payment to the lender, we have made the payment to the lending party, and the charge has been satisfied. So when the company makes the payment and satisfies the charge in full, it will file the CHG4 to the ROC within 30 days of the payment, and then ROC will issue you the certificate of satisfaction that okay, your payment is being done, and that is issued in the form CHG5. That we will discuss later. But listen to me one more. Listen to me. I'll tell you one more point, sir. For example, it is 30 days. We have read that there are 30 days given, that we have to file the CHG4 to the ROC within a period of 30 days. But suppose, sir, we are not able to file the form within a period of 30 days. Then what we will do? You can apply for the extension to the ROC. ROC will grant you the extension, and ROC can give you the extension of 270 days. In the law, it is written like ROC can extend this period up to 300 days from the date of satisfaction. So from the date of satisfaction, originally 30 days you were having, and now they are saying that extended period can be 300 days from the date of satisfaction. So effectively you are getting 270 more days. More 270 days, and you can file the CHG4 to the ROC. Now ROC will issue a show cause notice to the charge holder, to the lender, and ask the lender that company is coming to us and saying that they have paid you the money. You just confirm that your money is received or not, your loan is repaid or not. Then only we will release this charge. Now there can be two possible cases, and ROC will stipulate the time period in the show cause notice that within this time period you have to reply. But the time, whatever the ROC will stipulate in that notice, that time period shall not be more than 14 days. That time period shall not be more than 14 days. And now the charge holder will be doing two things. Either he will raise the objection or he will not raise the objection. If he will not raise the objection, the ROC will issue CHG5. Yes, your charge is released. You have repaid the amount. Your charge is released. But if the ROC will, if the charge holder is raising the objection, then ROC will record that into its notes and inform to the company that so and so objection is raised by the charge holder. Now, very, very important point on which the institute has asked a question, that there is no need to send a show cause notice to the charge holder if the form of CHG4 is filed to the ROC and that is signed by the charge holder. So it is apparent now that charge holder has already signed it. If charge holder has already signed it, then why you are asking him again and again? Then you need not to ask that person again. And company shall preserve the copy of the instrument up to 8 years from the date of satisfaction. Then section 83 is another very important section. Sir, you are saying important with every section because institute has asked question on every section. 4 marks question they have asked on every section. ROC suo motu register the satisfaction. Neither the company, neither the borrower has filed the CHG4 to the ROC. Neither the company has filed the CHG4 to the ROC, nor the lender has filed the CHG4 to the ROC. But ROC is having the evidence. ROC is having some evidence that yes, this charge has been already released. This repayment has been done and the charge has been released. Then can ROC suo motu register the satisfaction? Yes, ROC can suo motu register the satisfaction, but evidence must be there with the ROC that yes, definitely, surely this charge has been satisfied. So if the ROC being satisfied on an evidence with respect to satisfaction of charge, the ROC enters the satisfaction of charge in the register of charges and inform the parties by issuing CHG 5 within 30 days of making the entry. Oh, now section number 84 says that if any person receives, suppose when we create the, let's say you just think that when we create a charge in the asset, when we create the charge on the asset in favor of some other person, then sometimes it is ordered that you have to appoint a receiver who will manage this property, who will take care of this property. So if any such order is passed and a receiver is appointed. So whenever he will be appointed, at that time also we have to file form CHG 6 to the ROC about his appointment, that so and so receiver is being appointed. And whenever he will be seized from that appointment, whenever he will be leaving that post, that position of that receiver or manager, then also again you have to inform to the ROC. So section 84 is nothing. It is just saying that whenever the receiver will come, you have to file ROC, you have to file CHG 6 to the ROC. Whenever the receiver will go, he will cease to have that appointment, you have to file the CHG 6 to the ROC. Now always learn and recall and remember and read and revise section 81 and 85 together, because they both of these sections are related to register of charges. Section 81 says that register of charges, which means company has created charge on which asset, when the charge was created, and etc etc. All that record that is contained in the register of charges. So this register of charge is to be maintained by the ROC also, and register of charge is to be maintained by the company also. That means I want to say that register of charge is to be maintained by two persons. First is company also, and second is ROC also. But for ROC, they have played a game here. Section 81 says that register of charge is maintained by the ROC for each company. How the ROC will maintain? Sir, ROC is having so many companies, and companies are creating so many charges. How ROC will create a record of all that? Nothing. They have said that whatever the information company files on the MCA portal, so whatever the information related to the charges of the company is maintained on that MCA portal, that is deemed to be the register of charges maintained by the ROC. They need not to maintain separately a register. That information is deemed to be the register of charges maintained by the ROC, and it is open for inspection to all on the payment of fees. You can pay the fees and you can inspect that. Then section 85 says that company also has to maintain the register of charges, and company will maintain this register of charges in the form number CHG 7, and company has to maintain this register at the registered office only. These points are important for the MCQs as well. And the copy of instrument creating charge shall also be kept at the registered office. Now, register of charge and that copy of instrument, members can inspect during the business hours without any payment of fees. They can freely inspect, and any other person can inspect during the business hours, but they have to pay the fees as well. Some important points and additional point you also have to remember that first, the following particulars are to be written in the register of charges, which is maintained by the company. When the company maintains the register of charge, you have to write down these points. All the charges registered with the ROC. You have to write the particulars related to all the charges registered with the ROC. You have to write down the particulars of property acquired subject to charge. It means you have to write down the particulars of that property on which charge was already created and you acquired that property. You have to write the particulars of that property as well. And you have to write the particulars of modification or satisfaction of charge also. And entries in the register of that charge shall be authenticated and verified by CS of the company or director of the company or any other person authorized by the board of directors. And you have to preserve, this point is also important for the purpose of MCQ. You have to preserve this register of charge permanently, but the copy of instrument is to be preserved for 8 years. Hello, listen to me, I am talking to you. You have to remember this point. Please remember this point. You should not do the mistake on these silly points, these minor points. Register of charge is to be maintained permanently, but copy of instrument is to be maintained for 8 years. Do not do this mistake that register of charge is to be maintained for 8 years. Register of charges is to be maintained permanently. Copy of instrument is to be maintained for a period of 8 years. And the last section, that is 86, and 86 talks about punishment for, actually it is last 80. In 87 you will see that there is some condonation of delay and extension. You are asking, that is for that. 87 is for that. 86 talks about the punishment for default under this chapter. So if the company makes any default under this chapter, penalty will be applicable rupees 5 lakh. Officer in default will be liable to a penalty of rupees 50,000. And if it is proved that any person willfully furnishes false or incorrect information, knowingly you are furnishing false information, incorrect information, misleading information, or very important information or material information, you are suppressing that. You are suppressing the material facts. You are concealing the material facts, concealing the material information, then such person will be liable under section 447. That officer in default will be liable under section 447. That is penalty for fraud. 447 is for fraud. Now relate the section 77 subsection 3 consequences with this section of consequences 86. Sir, what is section 77 subsection 3 saying? It says that when the charge is not registered, what are the consequences of non-registration of charge? The charge shall become void against the liquidator. It means if the charge, you have created a charge, but you have not registered that charge, and now the company goes into liquidation, the liquidator will consider that charge as a void charge, and that lender will be treated as an unsecured lender. The priority the charge holder was having, he will be, or it will be losing the priority. He will be, or it will be losing the priority. It will be reduced to the level of unsecured creditor, and the charge shall become void against the liquidator. Liquidator says that this is not a charge in our point of view. We will not consider this charge. Now this charge is invalid. Or charge will become void against the other creditors also. Sir, for example, this is the company KK Limited. KK Limited took loan from SBI, created a charge in the favor of asset, but created a charge in the favor of SBI on that asset, but the charge was not registered. And now on the same asset, the company has taken the loan, and now on the same asset, company has created a charge in the favor of Kotak Bank. So this charge which was not registered, this will be void against the other creditors also. Kotak will say that we will do not consider this charge. Who will be having the priority over that asset? Kotak Bank will be having the priority of that asset, because the company has created the charge in the favor of SBI, but the charge was not registered. Later on, company created the charge in the favor of Kotak Bank on the same asset, and that charge was registered. So Kotak Bank will be having the priority over that asset. So that is written over here. Charge shall become void against the liquidator or against the other creditor who acquired the interest in such property. The charge holder, earlier charge holder, loses the priority, and the charge holder will be reduced to the level of unsecured creditor. Now company was sitting aside and company was smiling. Oh, the charge is considered as invalid. Okay, so there is no obligation on us also. We will not repay the money. But it is said that no, it is not like that. Charge remain valid against the company. Charge is becoming void against the liquidator, against the other creditor. Liquidator will consider it as void. Other creditors will consider it as void. But for the company, it will not be a void charge. Because company is saying, you just understand. Company is saying, you have considered this charge as void, and we have created this charge on the loan taken. So if the charge is void, then the loan transaction is also void. And if the transaction is void, we are not required to pay any money to the lender. So law says no. The charge remains valid against you. Your obligation will not be affected. Obligation of what? Obligation to repay that amount. That will not be affected. So all these sections, all this provision of this section, section 77, subsection 3, shall not prejudice any contract or obligation for the repayment of money secured by charge. Charge will become void, but your obligation remains intact. That you have to pay. Your obligation to repay will be there. That is not becoming void now. Oh, you can read this example. That will be helping you. But I've explained you right now. And section number 87 says that. Suppose you have not filed a form to the ROC. CHG1 you have not filed, 4 you have not filed, some forms are there you have not filed to the ROC. Then you can apply to the CG through the form number CHG8 that we forgot to file. But that omission was accidental and due to inadvertence. That was accidental, that was not intentional. So, and it does not affecting the creditor or shareholder's interest. Please allow us, and please condone our delay, please condone our omission, and please allow us, please grant the time to us so that we can file that form to the ROC. So you can take an extension from the CG here that is given in section 87. In section 87, there is one more case given that if you have filed something but there was some misstatement in that or some omission in that, you have not omitted to file the form. You have filed the form, but in the form you have omitted something. You forgot to write something in the form. Then you can apply to the CG for the rectification of that form, and that you have to explain that omission or misstatement was accidental and that misstatement is not affecting the interest of any shareholder or creditor. Then in that case, CG may grant you the rectification also, and you can rectify your mistake or misstatement. Now there is one more rule, that is rule number 13, and rule number 13 says that if the company is under insolvency or the company is under liquidation. Now let me explain you some extra topics, because then only you will be able to understand these lines. There is a code that is IBC, insolvency bankruptcy code. Whenever a company is into the insolvent position now, so we have to start a process that is called CIRP. CIRP means corporate insolvency resolution process. Corporate insolvency resolution process, or you can say it is a revival process. It is a revival process. Company try to revive itself, like we try to revive that company which is insolvent, which is becoming insolvent. That is called revival process. But if after the revival process, if the company is not able to revive, then the company will be entering into liquidation. So there are two different processes. First is liquidation, other one is CIRP, revival process. Whenever the company enters into the revival process under IBC, then there is a professional appointed that is called interim resolution professional and resolution professional. And all the powers of board of directors and all that powers are being given to this IRP or RP. Now the board will not be having the powers. Board is not able to exercise the powers anymore. The IRP or RP will exercise the power. And in the case of liquidation, liquidator is appointed. And in that case, the powers are transferred to the liquidator. Board of director is not able to exercise the power. Liquidator will exercise the power. So they are saying if the company is under insolvency, then form CHG1, CHG4, CHG8 and CHG9, they are to be filed by interim resolution professional or resolution professional. But if the company is under liquidation, then these four forms should be filed by the liquidator, not by the company. So that is a rule number 13. You have to keep this point also in your mind. And very beautifully, we have covered this very, very cute chapter, very, very small chapter, very, very sweet chapter. And now let me discuss some questions related to this chapter and you will be able to understand that. I would say, please go through the writing practice playlist, and please, if you're not, because that is actually in Hindi. That is actually in Hindi, not exactly in Hindi, it is in English. If you are able to understand that how we are writing the answers in that lectures, then definitely watch that. If you are not able to understand it purely, then what you should do, that you should keep that PDF in front of you. You just see the question, you start writing the answer on your own, and then match it with the answer which I am writing in that lecture. Then you will be able to understand that what mistakes you are actually doing and what points you have to remember while writing your answer. That will actually help you. So if you are not able to watch the lecture, at least take that PDF and with the help of that PDF, start doing the questions. That will actually help you to like how to write the answer in your examination. That is going to change your answer presentation in your examination, I am saying you. So that is why I am saying, please, please, please follow those PDFs for your writing presentations. Right, sir. Let me discuss some questions also, then you will be getting confidence, more confidence that, oh yes, we are able to solve the paper as well, because ICI is asking in the question in a similar manner what we have just read. Sir, yes. We will discuss some questions. See this. State with the reasons whether the following statements are true or false. The ROC of the company is not bound to issue notice to the charge holder if the company gives intimation of satisfaction of charge in the specified form and it is signed by the charge holder. Yes, true. If it is signed by the charge holder, then ROC is not under an obligation to issue the show cause notice. The ROC may allow the company or holder of charge to file intimation within a period of 300 days of satisfaction on the payment of additional fees. Yes, true. Primarily, originally, initially, 30 days are allowed. But if you will make an application for the extension, ROC will grant you the extension, and in that case, you will be able to file the extension. You will be able to file that satisfaction form within a period of 300 days. Got it, sir. Now, read this question. SG Limited hypothecated its plan to a nationalized bank and availed a term loan. The company registered the charge with the ROC. The company settled the loan. The company requested the bank to issue the letter confirming the settlement of loan, but the bank did not respond. State the relevant provision. Nothing you have to do. Some students get confused and they will say, oh, this is that point that lender is not responding, so the ROC will register the charge. And no, this is not that point. ROC did not issue show cause notice to that bank, and now the bank is not responding. That we have read that ROC will issue show cause notice to the bank, and the bank should respond. The bank will be responding or not responding. This is not that case. This is not that case. Here the company is asking a no objection certificate from the bank, and bank is not responding. You have to tell the further course of action. What we need to do now? Nothing. You just have to follow section number 82, file CHG4 to the ROC. ROC will automatically on its own issue the show cause notice, and further course of action will be as per section 82. So you have to write down the provision of section 82 only. Oh. Then I'll discuss some more difficult question. Not difficult, but yes, there is one another question. That company has taken 30 lakh rupees working capital loan by offering stock as a security. Whether the stock which is created, whether the stock, is it required to create charge for working capital loan? Yes, you have to create a charge and you have to register that charge also, what you have created on the stock. Company has taken 5 lakh rupees overdraft facility by keeping the personal guarantee of a director. Personal guarantee of director is not the asset of the company. Company can create a charge on the asset of the company, property of the company, or undertaking of the company. But if the director has given his personal guarantee, that is not the asset or undertaking or property of the company. So this is not like covered in the definition of charge. Company is not required to create a charge on that, and there is no need of registration of that charge. Then they are asking the extension of the time period, that you can easily write down. There is nothing difficult in that. One more point is there. Moonlight Limited is having an establishment in USA. They are having some property in the USA. It obtained a loan there. Company has taken the loan in the USA. Establishment is also in USA. Charge is also created on the in the USA. But the company has not registered that charge with the ROC, and ROC sent a notice to the company that you have created a charge but you have not registered that charge. Company contended that, sir, our asset is in USA. We have taken loan in the USA. We have created the charge in USA because lender is also in USA. So there is nothing in India. So we need not to register this charge. You tell whether the contention of company is correct or not. No, sir. Contention of company is not correct. Company has to get that charge registered with the ROC as per section 77. Then one or two questions are there. Yes, that Antariksh question we have already discussed while doing that section 80 deemed notice. There is one more question that I have to discuss, that is, yes, Ranjit acquired a property from the company which was mortgaged to Pyramid Bank. He settled the dues to the Pyramid Bank in full, and the same was registered with the sub-registrar, who noted that mortgage has been settled. Now neither the company nor the bank filed the particular of satisfaction to the ROC. ROC is not getting any information, but ROC got the evidence from Ranjit. Question is asking, can Ranjit approach the registrar and seek any relief in this regard? Yes. If Ranjit provides the evidence to the ROC, Ranjit can approach to the ROC, and if ROC gets the evidence that yes, actually the charge has been settled, actually the loan has been settled and the charge is to be released, then ROC will suo moto issue the CHG5 and the charge will be released. So here is the question of section 83 that I was also saying at the time of explaining you this topic. Got it? Got it, sir. So very beautifully we have covered this very cute and simple chapter. You can understand this chapter very easily from this revision lecture, and definitely please like the video, please write down the comment, and definitely let me know your feedbacks, and you have to share this video with all your friends in all the groups wherever you are added, or in your like groups or friend circle, and everywhere wherever you can share, you have to share this video with all your friends. And see you in the next revision video covering a very beautiful chapter. And till then, take care. Tada, bye bye. Keep working very hard, as someone somewhere is waiting for our success. Thank you so much. Take care. Tada, bye bye.